do you guys say? We'll get started. Welcome to Plan Commission meeting. Tonight is Monday, September 22nd, 2014. First order of business is roll call.
Elam.
Here.
Farrell.
Here.
Keach.
Here.
Neff.
Here.
Hagel.
Here.
Ritterbusch.
Here.
Smock.
Here.
Westlake.
Here.
Zilbert.
Here.
We have a quorum.
Great. Thank you very much. Next order of business is the approval of minutes for our meeting August 25th, 2014. A copy of those minutes were provided with your packet. Everybody review those? Any questions, comments, or changes? Hearing none. Do we have a motion?
So moved.
Thank you. We have a motion. Do we have a second?
Second.
Was that Jeff?
Yeah, we made the motion.
All in favor? Aye.
Aye.
Opposed?
Thank you, Roger. Next thing here we have tonight is our public hearing regarding petition number 14-10ZA. Before we get into this, our council will provide a brief description of the public hearing process.
Thank you. Public hearing is being held tonight pursuant to published notice. Any person wishing to make a comment to the Plan Commission will be afforded an opportunity to do so. Will give their testimony under oath or affirmation. At the conclusion of the public hearing, the Plan Commission will make a recommendation to the Village Board. The Plan Commission makes recommendations only. The Village Board is responsible for taking final action on this matter.
Great, thank you very much. This particular petition, again, 14-10ZA, is the Village of Morton requesting a zoning amendment for 180 South Detroit Street. This will change from B3 to I1. There's no one here, obviously, tonight except our good friend, Trustee Newhouse. Would you like to speak to this?
Sworn, I believe.
I am Stephen E. Newhouse, and I'm speaking tonight in my capacity as trustee representing the Village of Morton municipality in this petition to rezone the property identified in the agenda this evening. This is the former Farm and Fleet site, which you all know was acquired by the village in the process of the development that brought the new Farm and Fleet site into existence. That property, you also probably know, has been sold, and the purported use, the expected use, is light manufacturing. In order to execute the sale, the village, as the current owner, needs to execute a rezoning from B3 to I1. From a pure zoning standpoint, I guess my position would be, and the village's position would be, that this brings us closer to the industrial park concept for which Detroit was originally developed, and is consistent with adjacent zoning. It actually reduces the amount of patchwork zoning on Detroit Avenue. So we are looking tonight for a finding by the Plan Commission relative to this motion, or to this petition. I'll take questions if you have any.
Thank you, Trustee Newhouse. Are there any questions from the table this evening? Everyone can see the colored zoning map that was provided in the packet. And it's always been the intention, I think, out here to try to keep the zoning consistent. So, hearing no questions, do we have a motion to approve petition number 14-10ZA?
So moved.
We have a motion. Do we have a second?
Second.
Thank you very much. Roger, when you're ready, if you could call this.
Keach.
Yes.
Neff.
Yes.
Hagel.
Yes.
Ritterbusch.
Yes.
Smock.
Yes.
Westlake.
Yes.
Zobrist.
Yes.
Elam.
Yes.
Farrell.
Abstain.
Motion to approve.
Okay. That's the last part of the public hearing process. Do we have a motion to, well, we need to get out of this thing. We need to get down to Roger. And Roger, do you have anything for the committee tonight? You said
Nothing tonight.
nothing tonight. How's your brickwork going? It's looking pretty good.
It's done
For now.
for now.
You're making me need to redo mine next. All right, Mr. Newhouse, what do you have for us this evening?
Two items, Mr. Chairman, and speaking of now in my more normal
That's right.
capacity as the liaison to the Plan Commission. I have two legal advisories, one from the Illinois Municipal Review, which some of you may see, and one from Miller Hall and Triggs. One is related to a recommendation that all bodies have a procedure for handling public comments during a hearing. And I think we have a procedure for the Plan Commission. I don't know if it's been reviewed in a while, but given the advice expressed in the article, it might be worthwhile to review that and ask Mr. McGrath to confirm, not necessarily this minute, but at some point, that we have a legally acceptable process in light of the recommendation from the municipal league attorneys. And the other is from another local legal group that advises on public policy matters, and that has to do with the requirement for statement of address. We typically ask people to state name and address. Well,
Right.
we are now advised that courts have found that that is inappropriate, acts as a restraint on people's willingness to speak out or to testify. And so, again, I'm not quite sure what the procedure ought to be, but I wanted to bring it to your attention. Mr. McGrath can advise, but apparently we may continue to ask for people to state their names. We cannot legally, as I understand it, require them to state their addresses. I think it might be fair to say in a meeting that you may state your address if you wish, but you are not required to do so. Again, I would defer to legal counsel.
And that's based on the recent public access counselor line of decisions, and it arose out of circumstance where a person was told they had to do it before they could speak. There's two reasons why I think it would be appropriate to continue to ask people to do it. If someone refuses or declines, you can't force them to. One of which is some of the comment rules that we've adopted regarding the ability to cross-examine depending on where you live in relation to the property. And so if you're unwilling to state your address, unless we have an address list handy, you're unable to cross-check and make sure they're eligible to cross-examine if they so choose. So based on that reason alone, I would suggest you could continue to ask for that. State, please state your name, and we would appreciate it if you could state your address. If someone does decline or doesn't state it, based on that public access counselor's decision, we can't say you can't comment or we can't interrupt them and tell them it's required.
Okay.
Would this extend on then to list of potential objectors of surrounding properties? I mean, does it go that far?
In terms of
Addresses?
well, it only the decision was limited to saying if someone's going to speak, you can't make them give your address.
Right.
And it doesn't really speak to any consequence for addresses beyond that in terms of whether we make people bring them to us if they're bringing a list with them in support of their case. That issue, and we had that the last time where the lady brought in a list of other objectors. Right. There's an evidentiary issue when people do that. You're a hearing body, and just like in a court, the expectation is if you want to testify, you should be there and be present. So I always tend to suggest resolving those issues in terms of the weight you assign, and it may be appropriate to give less weight if somebody's not here. The logical extension of that rule would be if someone wants to submit a list like that, I don't think you would have to or would be wise to insist that they provide addresses. But at the same time, I would suggest a list like that at a starting point should not have much evidentiary weight to the commission, because it's not a substitute for somebody being here and affirming or swearing under oath and giving their testimony.
Okay.
I actually think it's a great point, and Pat and I talked about it a little bit after the meeting last time, and I think there probably is a need for some review on that process, if for no other reason, so that Jeff or I are able to better handle the room, as it were, and make sure that there's some level of order to this. But part of the reason why, I didn't see it necessarily as evidence of anything other than what they were discussing, but what was interesting when I looked at the comments on the last meeting in particular, I do like to get an idea of where the mindset is, when people have such convictions to the contrary. And one of the things I noted in there was it said that the churches should be treated the same as everybody else, and that was in there. And I think that speaks a little bit more to what Trustee Newhouse was saying at the meeting, is that there was probably a special use is misunderstood in many cases. It's just misunderstood. It's seen, because the word special is in there, maybe, it's seen as something over and above what is typically seen in those particular ordinances. And that's maybe a misinformation issue that we should, I don't know how you tackle that. But
And it highlights one of the reasons why a list of people who object to action who aren't in attendance at the meeting does not bear evidentiary
Absolutely.
credibility.
Yep, without a doubt.
Because how you present the question influences how people answer. If you go door to door and say, should the church be able to violate the village
Right.
laws and do something illegal just because they're a church, a lot of people are going to say, no, I don't think they should.
Right.
And so that is a good point to highlight why things like that don't bear weight.
Yeah, okay. I'm in agreement.
I have nothing else, Mr. Chairman.
Well, thank you very much. I appreciate that. It's, I think, probably wise of us to freshen up on that. So if we have nothing else, do we have a motion for adjournment this evening? I'm sure there's some Bears fans anxious to watch another loss.
So moved.
We have a motion. Do we have a second?
Second.
There we are. Thank you very much. Mr. Spain?
All in favor? Aye.
Aye.
Opposed?
Thank you.